So it turns out a grand jury won't always indict a ham sandwich. I swear I've never seen a legal joke write itself so easily. Okay, so a grand jury just failed to indict the man who famously threw this sandwich of ham variety at a federal agent in DC. Some view this man's shocking sandwich slinging as a form of resistance against the federal law enforcement presence in the city. And he's become a bit of a local celebrity.
Now, as for the law and the joke here, before felony criminal charges are brought, a prosecutor typically first presents the case to a grand jury. If the grand jury thinks that the charges are appropriate, only then do they indict the defendant. And the prosecutor then moves forward with those actual charges.
The thing is, grand juries, by design, are totally one-sided. Unlike a real trial, it's not prosecutor versus defense. It's just the prosecutor and the grand jury, by themselves, usually without even a judge.
The defense actually has no legal right to be present or even be informed about the proceedings. The prosecutor presents all evidence themselves, and in most jurisdictions, and this one might actually shock you, the prosecutor doesn't even have to present evidence that's favorable to the defense. It's this total one-sidedness and the whopping 99% indictment rate that led one New York attorney in the 70s to famously opine that a grand jury would indict a ham sandwich, with the phrase becoming a common legal joke amongst attorneys ever since.
All that said, as we see here in the DC case, grand juries do sometimes refuse to indict, and their refusal typically signals that society disagrees with something. For example, during the Prohibition era, grand juries frequently refused to indict on alcohol-related offenses.